My name's Robert Ensor. I've included a few gongs there. Chairman of the Netherlands Association of Interpreters and Translators, member of the FIT Council since a while back, and chairman of the FNV Vision and Strategy Committee. If I can just explain that, why I've included that and why I think it's important. I think as a professional association of interpreters and translators, we need to embed ourselves very firmly in the mainstream union movement within our various countries if we really want to strengthen and make sure that we achieve our rights as people who are reliant on the sale of their labor to earn their income. Do translators and interpreters in the Netherlands have a collective labor agreement for their work? The answer is simply no, we don't. Is it possible for interpreters and translators, as sole traders or self-employed people, to have their own collective labor agreement? No, not under the present rules, we can't. Is it possible to fix rates and conditions for interpreters and translators in a collective labor agreement? No, not yet. But this is looking increasingly likely, and this is what I want to talk to you about today. Because being stronger together, or making our common future, bumps up against a whole lot of legal and political issues around the way in which the economy in Europe and in our countries is organized. As freelancers, making our future together, to what extent can we do that together? To what extent can we decide on the value of our own labor and decide on the conditions under which we do that work? Okay, and if you look at 2 and 3, they look as though they contradict each other. So we don't have a collective labor agreement, but we might well have it in the future. But that doesn't contradict, and I'll explain why. It's a very difficult thing to get your head round, but I'll explain it. The EU treaty, the Treaty on the Functioning of the European Union, Article 101, is really the heart, you could say, of neoliberal Europe, which decides that the market cannot, nothing can stand in the way of competition. Anything that restricts competition is prohibited by European law. It prohibits practices and agreements between undertakings, and an undertaking is anything from a multinational to a freelancer, which restrict competition on the common market. And these practices include price fixing, agreements on conditions of supply, market sharing, so you can't, for instance, decide that, as happened in The Hague, that people who come and clean your windows would serve a particular area of the city, and if someone else from another area came into their area, then that was prohibited. They divided the city up. That was illegal. You're not allowed to do that. And you're not allowed to boycott another company. So if, for instance, interpreters and translators who work for a large agency who win a tender cannot agree as companies, as individual self-employed people, to not work for the company, not work for the contractor because the rates are too low or because for any other reason. That's referred to as a boycott. Also, the agreements don't have to be explicit. You don't have to agree not to work for the big contracting company. If the contracting company can't find interpreters and can't find translators, it's generally accepted that a competition authority will look at the facts and decide that whether or not there's an explicit agreement, there is a concerted practice. In other words, the market behavior of that group is coordinated, and that in itself would be considered to be an infringement of the law. So we see that we are restricted, because we're self-employed, because we're considered to be companies, from doing a whole lot of things which relate to the way we work. However, there are a number of exceptions. Schemes introduced by the government, certainly in Holland under Dutch law, competition law, which will be the same, I think, in most European countries, fall outside the scope of competition law. So, for instance, a government scheme on rates, government scheme on court rates that interpreters and translators receive from the courts falls outside of competition law. Collective labor agreements, in principle, always fall outside of the scope of competition law, even if they affect competition. This was an issue a number of years ago where a company, also a Dutch company, took a case up to the European Court because they felt that there were clauses in a collective labor agreement which had a negative effect on competition, and they wanted to outlaw collective labor agreements. However, the European Court decided that Europe also has a social policy and that collective labor agreements, which, even if they have an effect on competition, are not illegal. So competition law excludes collective labor agreements. What this means is that there's a division within Europe at the heart of talking about labor and work between the self-employed, the businesses, as it were, and on the other hand, people who are in employment. And what one can do in employment, when it comes to talking about wages and the value of your work, one cannot do if one is a company and if one falls under competition law. Two completely separate worlds. Finally, what I want to say was, in that world divided up in this way, of course, if you want to talk about rates and you want to talk about the value of your labor, then you have to make sure that in some way it falls under labor law, in some way that it falls into the category of labor law so that you can talk about the value of your labor. The final exception are the bagatelle clauses. In Holland, if you make an agreement and it only relates to 10% of the market with no appreciable effect on trade between member states, then you can make agreements around rates and tariffs. What we certainly want to explore in this regard is the question of the delivery and receipt of translation work through the internet. In our view, the internet is a global market. Translations can be received and sent to any translator on the internet. So if one looks at the complete global market for translation work through the internet, then the total Dutch, all the Dutch interpreters and translators would be less than 10% of that global market. So the question which arises is, can we enter into price agreements with the entire group of translators who do work via the internet, given the fact that this is a global market? That's something that we want to look into. Right, then just to make a little diversion, citizens and their organizations always have the right to organize protests against government policy, such as a framework agreement, a tender, etc. So it is quite acceptable, even if you are self-employed, to form an organization and campaign against the government tender, framework agreement, or some sort of government policy. However, once the tender has been awarded, collective action against the company awarded the contract can be seen as a concerted practice. In other words, once the company has been awarded the contract and then goes looking for parties in the market who can do the work and comes across an agreement not to work for this particular company, in our case Concorde would be the good example, then the competition authority could take it up and declare that you are organizing a boycott against a legitimate company which has been given a contract. So it's important to tackle it at the source, to tackle the political decision when it's made. Okay, no distinction is made in EU competition law between multinationals and sole traders, between companies that utilize the labor of others and freelancers or sole traders who depend solely on the sale of their professional labor. However, distinction is made between employees. They have the right to determine the value of their labor through collective bargaining. They have the right to withhold their labor collectively to strike, and on the other hand, freelancers who have no right to collective bargaining to determine the value of their labor and no right to withhold their labor collectively. Okay, so in Holland, looking at the situation, 20% of the labor force is now self-employed. That means that 20% of the people who have no other source of income than the sale of their labor have no right to collectively decide with each other what the value of that labor is. And they have no right to campaign, and they have no right to stand up together and to refuse to be exploited simply because of the nature of the contract that they have with their contractor. And that's something that my union, in any event, not the Association of Translators and Interpreters, but the Union Federation, is not happy with, and they want to see that changed within Europe. The distinction should be between people who live from their labor and people who live from other people's labor. Right, is there, sorry, that should be space to discuss rates. Pace, we'll get into the pace at some. Is there space to discuss rates and conditions of work and to enter into agreement on these as sole traders or as freelancers? The answer to that is not quite yet, but the space is likely to be opened up very soon. And that's really the key of what I wanted to say. In Holland, the Dutch orchestras employ self-employed people to replace sick musicians who fall ill. And the musicians themselves felt that there was a trend towards employing increasing numbers of self-employed people, musicians, because they were cheaper, more flexible, etc. So they wanted to include in their collective labor agreement clauses governing self-employed people who work for the orchestras. In other words, if someone comes and works for the orchestra, they should be paid the same rate at least as people who work in the orchestras. They also wanted to, a number of other things that they felt were important, as if a musician is employed as a freelancer to substitute someone else and falls ill, that they should also have a right to continued payment of their fee for the period that they're ill. And a number of other conditions which apply to people in employment were also extended to people who are musicians who are employed on a freelance basis. The employers objected to this, and the Dutch Union of Musicians took the matter up with the court in The Hague and argued that the position of the competition authority was illegal. And the court in The Hague, when it went on appeal, wrote to the European Court of Justice and asked for an opinion on whether conditions applying to freelancers and self-employed people could be included in collective labor agreements. In other words, could that sharp distinction that there is be blurred a little bit on legitimate grounds? And the conclusion of the Advocate General, which is now going to the European Court for a final judgment, and it's very likely that the court will take over this judgment, and I'll read it out in full. Provisions in a collective agreement concluded between, on the one side, an association of employers, and on the other side, trade unions representing employees and self-employed persons, which provide that self-employed persons who, on the basis of a contract for professional services, perform the same work for an employer as the workers who come within the scope of that collective labor agreement, must receive a specific minimum fee. And they fall then within the scope of Article 101 if they are entered into in the interests of and on behalf of the self-employed persons. In other words, if a collective labor agreement is entered into solely in the interests of professional providers of services, freelancers, self-employed persons, then Article 101 applies. In other words, it is prohibited. You cannot enter into, according to the advice of the Advocate General, you cannot enter into a collective labor agreement for self-employed people. However, it falls outside of Article 101 if they are entered into in the interests of and on behalf of employees whose employment and working conditions they directly improve. In other words, if in a collective labor agreement you enter into clauses about the rates and tariffs of self-employed people in order to protect the rights of people in employment, then it is acceptable to have set rates and set conditions for self-employed people. It is for the, and then the rest is just not so important. Now how do I go back? Okay, but what does it mean if they are, that clause, if they are entered, if the collective labor agreements are entered into in the interests of and on the behalf of employees whose employment and working conditions they directly improve? And in this interest, it's interesting to look at what the Advocate General says. He says, in particular, the objective pursued by the provisions of the collective labor agreement was to prevent social dumping. FMV maintains that by providing a counterweight to the potentially lower costs borne by employers when replacing workers with self-employed people, the provisions in question are intended to ensure that employers do not lose all incentive to hire workers. In other words, if the rates that are paid to the self-employed are so low that there is no incentive to employ people in regular employment, then there's every reason to include minimum rates for self-employed and freelancers in a collective labor agreement, and it's perfectly legal according to the Advocate General. What that means is if we campaign to have, sorry, what was it called, your company in Britain? Capita. If we campaign for employment of interpreters by Capita because there's such a volume of English and French interpreting, and we want to improve regular employment for interpreters and translators employed on a permanent basis or whatever by companies, then that also gives us the right to include minimum rates in a collective labor agreement, because then we will be guaranteeing the conditions of employment of people in regular employment within the industry. So this means something that we have to do something completely, if we want to be able to talk about rates and conditions collectively as self-employed people, we can only do that by doing something very counterintuitive, and that's by fighting for more people to be employed permanently by companies like that, and including rates that make sure that we don't compete with them so that their jobs aren't endangered. So in other words, the ideal situation would be one where Capita, it would make no difference whether they employ someone on a freelance basis or whether they employ them on a permanent, regular employment basis. And I think we all know intuitively that our rates would be considerably higher if that was the balance that had to be achieved. Okay, then just to expand a little bit on this concept of social dumping, I believe that the risk, says the Advocate General, I believe that the risk of social dumping may clearly and immediately affect those conditions, the conditions of employment, for two reasons. One reason is that having a safe and stable employment is clearly for workers even more important than the improvement of, for example, their working hours or annual leave rights. If it were convenient for the employers from an economic point of view to replace workers with self-employed persons, there would be a risk that many workers might immediately lose their job or become gradually marginalized over time. The elimination of wage competition between workers, which is in itself the very raison d'etre of collective bargaining, implies that an employer can under no circumstances hire other workers for a salary below that set for in the collective labor agreement. On that basis, and from the perspective of a worker, there's really no difference if he is replaced by a less costly worker or by a less costly self-employed person. And then he goes on, unless workers have a certain level of protection from social dumping, their ability and incentive to enter into collective bargaining with employers would be seriously weakened. From that angle, the possibility for workers to include in collective labor agreements provisions designed to ensure the continuous existence of a certain number of positions of employees in the employer's businesses may be regarded as a necessary precondition for them to be effectively able to negotiate improvements of other employment and working conditions. So where does this leave us? If the European Court accepts the opinion of the Advocate General, it will not be possible for the self-employed to enter into collective agreements to protect their own interests. However, it will be possible to conclude agreements on rates and other conditions in collective labour agreements which protect employment in the sector and counter social dumping, which protect employees in the sector from downward pressure on salaries or which threaten their employment. In other words, we have to not see people in employment as our competitors, but in a way promote our own interests through promoting theirs, by promoting employment in the industry, etc. If associations wish to set minimum rates for translation and interpreting with the industry, assuming the Advocate General's opinion becomes law, they will be able to, and therefore should, in my view, campaign for more translators and interpreters to be employed as employees, for an increase in employment and against social dumping, campaign to protect the bargaining position of translators and interpreters in employment, and both of which can only be achieved by setting minimum rates for translators and interpreters working as freelancers within the industry.